Okay. Whoops.
Welcome, everyone. Thank you for joining me with the ABCs of Disability Planning. With me today, I have Kim Martin. Kim is an estate planning attorney. She is an attorney, but she's not your attorney. This is going to be a disclaimer. None of this is legal advice. She does not know your situation. She's not speaking to your situation. This is for education, information, and entertainment purposes only. I say that, and I've said it in the past with other professionals, because I think it's easy when you listen to a professional talk to think they must be talking about me and my situation. And that's not fair to the professional or to you unless they've had the opportunity to sit down and really get to know your situation. And today, Kim's going to talk to us about a wonderful, exciting topic that I know you all just can't wait to hear. It's divorce. And more specifically, divorcing when you have a child with a disability and things to consider. We had a podcast a while back about dispelling some myths. This is going to be a little more concrete. So with that introduction, Kim, thank you for joining me. I'm really glad you can be here today. Audience, I heard Kim speak at the Stetson Law Conference, which is, in my opinion, the premier special needs conference in the country, and it's held every year down in St. Petersburg, Florida. So, when I say you have an expert, you really, really have an expert, and I would, be taking notes. But thank you, Kim, for joining me.
Thank you for having me.
So, right before we hit record, you're sharing what your role is, and how you're an estate planning attorney. You're not a family law attorney, but yet you still get involved with divorces. And would you mind just repeating what it is you do, and then we can kind of take the conversation from there?
Sure. It's this very odd, highly specific thing that I do. And it's one of those jobs where, if you need me, you really need me. And if you don't need me, then you really don't need me. So I am sometimes hired by family lawyers. And as you said, I am not a family lawyer. I do not do divorces. You do not want me to do your divorce. I do not like to fight about things. I don't care who gets the beach house. That's not my job. My job in this situation is highly specific. So I will often be hired either by the divorce lawyer or by the parents, or one of the parents sometimes, to review a settlement agreement and advise as to the language that should be used in that settlement agreement, specifically so that we can make sure that the support that's being provided for the special needs child in this situation does not reduce or eliminate the child's ability to qualify for benefits like SSI and Medicaid.
And are you doing this around the country, or are you just doing this in your home state?
Well, I am licensed to practice in Georgia. So that is where I practice, and that's where I'm allowed to practice. I am a partner at a national firm called Harrison LLP. So we are in many states all over the country. So if a special needs divorce situation arises in one of the many states where we have an attorney that's licensed to practice there, then I might work in consultation with that attorney as well.
Okay. But it would be an attorney that would be with your firm, not with an attorney outside your firm.
I have never worked with an attorney outside my firm, outside of the state of Georgia. I could do that, I guess, if somebody wanted me to.
Okay.
I mean, ideally, there would be a special needs attorney in the state that practices in that state, but we are a little bit hard to find sometimes. So.
Well, you're also in high demand, right? I mean, there's because depending on the state you live in, your attorneys may not be able to specialize. I mean, I've been told that that's a word that a lot of attorneys aren't allowed to use. So, but attorneys whose focus or whose primary practice centers around disability planning or elder law, because the special needs and elder law, there's a lot of overlap. Mm-hmm. It can be hard to find.
It can be. There are a handful of us in Georgia. And, even within that umbrella of special needs planning, which is already fairly specific, there are so many little subspecialties like this, like divorce consultation, that, you're right, we're hard to find. So I do sometimes get requests from far afield, but a great place to look if you do want to find a special needs specialist that's in your geographic area is to check out the Academy of Special Needs Planners website. And you can just go to your state and it should list some professionals that work in your state. So that might not be a bad starting point.
Yeah, and I've listed that and I've referenced them in other podcasts as well. It's a great resource. I'll include it in the show notes. I'll make sure I include your firm in the show notes. So let's start with, you mentioned benefits for a child, and you mentioned, so in terms of, benefits, when is a child and when are they an adult? Let's just start there and kind of roll from there.
Okay, yeah, the answer to that question is actually more complicated than you might think. It would be great if I could just say, you're not a child when you turn 18. But for benefits purposes, that is not actually necessarily the case. So as far as Social Security is concerned, a child, for purposes of child support, it's even more specific than that. But for purposes of determining how the child support rules apply, you are a child if you are under 18 and you're unmarried and you are not the head of a household. But you can still be considered a child for purposes of determining how the child support rules apply to you up until age 22. If you're unmarried, you're not the head of a household, and if you're still in school or you're doing job training like voc rehab. So in many states, you're entitled to services from the public school system until you reach age 22. That's the case in Georgia. So it's possible that child support payments might be regarded as payments made to a minor child, even if the child is up to age 22.
And I'm hearing more and more states are allowing child support beyond age 18. New York recently passed a law. So you're going to want to check with your state to see what your state's child support requirements are.
Mm-hmm.
So if you're paying child support to a spouse, or your spouse is receiving child support and your child's over the age of 18, what happens?
Well, if you've got a child who is eligible for SSI and therefore Medicaid in most states, typically we don't care what happens for most kids before the age of 18 because their family resources are going to disqualify them from getting SSI. That's not the case 100% of the time, but much of the time that is the case. So for SSI qualification purposes, unlike the child support rules, it's easy. Once you're 18, as far as Social Security is concerned, you are a household of one, which means we stop paying attention to what mom and dad have. We stop paying attention to any resources that are out there to take care of you, except for your own resources. But in addition to that $2,000 means test, which is a resource test, there's also an income test, and that's where child support is problematic. So the rule, if you are considered to be an adult child, meaning you're over age 18, or if some of those other circumstances apply, you're over maybe age 22, whatever the magic age is where the adult child rules apply to you for child support purposes, the rule is we will disregard the first $20 of that child support every month. That's considered a personal allowance, so they don't count that against you. But all the rest of the child support payment is considered unearned income that's attributable to the child. And that's the case even if that money is getting paid to the parent, which it almost always is. We're not going to be making child support payments to our disabled child. But no matter who is getting those payments, we will disregard the first $20 and the rest of it will offset SSI dollar for dollar. So if you've got a parent who's paying, let's say, $900 a month in child support for an adult disabled child, we're going to disregard $20. So now we have $880 of unearned income being attributed to the child. So this year in 2022, the maximum amount of SSI that you can get is $841 a month. So obviously, if we are offsetting that $841 with $880 of unearned income, that's going to wipe out SSI completely. And in Georgia and in many states, once you've wiped out that last dollar of SSI, you've lost eligibility for Medicaid. So
what do
that's
you
a
do,
pretty big
Kim?
deal.
I mean, so what can you do? I mean, is it the case like with my survivor benefit plan from the military? Well, I'm required by law to have it go to a first party trust. Can you do that with child support? Are you allowed to?
You can, and in fact, if you don't, then you have a problem. That's our ultimate dream solution. And there are some things in between that people do that are not the perfect solution, but the ideal best solution to this problem is that you need to have your settlement agreement require that payments after the safe thing is to say after age 18, because age 18, remember, is the age when we're eligible, when our child is eligible for SSI, regardless of what the child support rules are. So the settlement agreement should provide that post-majority child support must be paid to a first-party special needs trust. And typically people will use a private trust that's known as a D4A trust, or sometimes you'll hear them called self-settled trusts. They all mean the same thing. They're all first-party special needs trusts. And a characteristic of first-party trusts that makes people upset about putting money into them is that the first-party special needs trust must have a provision that says at the child's death, Medicaid has to be reimbursed for everything they've ever spent on the child. So no one ever likes that. Parents often hate the idea that they're paying money into a trust that has a Medicaid payback. It's not such a big deal when you're talking about child support because typically, you need that money. It's there to be spent. So often child support will get paid to a D4A trust and it goes in and it comes right back out again because we're using that money to take care of the child.
Yeah, I have a little bit of a different perspective on the Medicaid clawback or payback provision. My son's waiver for self-directed is $85,000 a year, meaning the state of Maryland is paying $85,000 a year for my son, who right this year will be 23, assuming he lives to be 90. That is 70 years at $85,000 a year, which is over $5 million.
Yeah,
he
it's
will
not a bad
never
deal,
have
really.
that much money in a first party trust.
Absolutely. No, I think honestly, I don't think it's such a terrible outcome to have a Medicaid payback at the end of the child's life. I mean, of course, the first party trust is not where we want to go out of our way to put as much money as we possibly can. And if there is money in a first party trust, that's the first money we want to spend because we're not crazy. But, I think if your big overriding goal is I need to take care of this kid for his whole lifetime, once he's gone, what happens to whatever's left over is kind of secondary to me. So of course we would like to be able to send that money elsewhere to the other kids in the family or to our favorite charity or whatever. And that's what a third-party special needs trust is for. That's a classic estate planning trust, but we can't use a third-party trust in this situation because this is income that's attributed to the child, and therefore it's first-party money. And you can't put first-party money into a third-party trust.
And I think this is where people get confused because they'll hear, I have a special needs trust, and they'll assume they're good. I've even heard cases where Social Security hears special needs trust and they assume it's one type of trust. Now, let's say they'll assume it's a first party trust, not a third party or something. So you have to be very clear, I think, about what type of trust you have set up. And when you're working with somebody, I think you want to make sure you're looking for the language. You said self-settled for first party, right? I mean, it'll say that in the trust at some point, right? I mean,
right. Or it might say D4A that's the last little piece of the code section that actually allows us to create first-party special needs trusts. But the big telltale sign is that if you have a first-party trust, it is statutorily required to have a Medicaid payback.
And you'll see that when you're reading the trust document.
Yep.
And they can be beefy, right? They can be a few pages long.
They can.
So I would encourage, before you sign off on a trust, when you work with an attorney, especially if it's not a special needs attorney, because I know a lot of you out there are working with attorneys who might say they can do it all or sure they've got this. Trust but verify. What Kim is spelling out can really make a huge difference between benefits. If you lose your SSI, if you lose your Medicaid, you also lose your Medicaid waiver benefits. And that is your vocational, that is your personal supports, that is going to be your residential supports, and it's going to be your community supports. That's a lot to lose because somebody, might have picked the wrong thing in a form letter on a some software.
Mm-hmm. Well, and the first party trust, I really feel like the first party trust gets a bad rap because I think of it as a damage control trust. So if somebody does go to an attorney that's not really a special needs attorney and they create something that they call a special needs trust and it is not in fact a special needs trust, worst case scenario, it's fixable by just decanting or converting that non-special needs trust into a first party special needs trust. It's pretty hard. You can in theory judicially modify a trust to make it be a third party special needs trust, but of course that's what everybody wants to do. And you can do it if you can talk a judge into believing that the intention of the grantor was to create a special needs trust, but they just did it wrong. If only they'd known the right words, they would be in there. So, Your Honor, can we please have those words and can we just stick them in there and pretend that they were there the whole time? And that's called judicial modification. It can be done, but there has to be some language in the original trust document that says my intention is to take care of this beneficiary in a way that isn't going to supplant his benefits.
Yeah.
So sometimes that language is there and sometimes it's not. And if it's not there, you can use your damage control trust, which is the first party trust. And people get upset about that because of the Medicaid payback, but you're absolutely right. If it's a choice between putting something into a basket that's going to, ultimately reimburse Medicaid with whatever's left over, or just having to spend all that money before you're entitled to get any benefits at all, you're better off with the basket.
Yeah, and in Maryland, first party trusts are a little more complicated because they have to be approved by the state. So
yeah, that's the case in most places.
And it's important for people to know that because that adds an extra length of time. Right? I mean, if your child is 18 and you're getting SSI and it's going to take 3 to 6 months to get approved, and I don't know what the real time is, I'm just stating times. I think mine took me about 2.5 months to get approved by the state, and that was pre-COVID. So plan for that, right? I mean, if you know it's going to take a while.
Well, the trust could still be, they'll treat it as exempt until somebody says that it's not. But if somebody says that it's not, then you need to do something about that pretty quickly.
I just tend to be planned for the worst, and I'm paranoid.
Well, it's good to plan for the worst, though. That is the whole job of every estate planner in the world. What's the worst thing that could possibly happen? What should we do about that? And then you kind of work your way back from that.
I'm guessing you probably don't have an easy answer for this because you're not a family law attorney. But how would you bring up the subject of who the trustee is going to be? Because, if you're having a very high conflict divorce, I can see one spouse not wanting the other spouse to be the trustee. I mean, so what's the solution? And again, caveat, 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 you're not a family law attorney.
Right. I'm absolutely not, but this does come up. And so sometimes it's no big deal. Sometimes the paying parent says, absolutely not. I am absolutely not funding a trust that this other person that I don't like and don't trust is going to be the trustee of. And I mean, the logical response to that, which doesn't always work, is you're already paying money to this person in child support. It's just going into their bank account. They have total unfettered access to it. So what we're asking you to do is to pay money into a trust over which this person is trustee. And the trustee is under a lot more restrictions with regard to that money than they were when they were just a parent that was getting child support deposited into their bank account. So it's actually more limiting to make child support payments to a trust than it is to just give them to the other parent.
Let's explore that for a minute. Can you give some examples? I mean, what is it about a trust that makes it more limiting?
Well, first party trusts in particular, they are subject to a great many restrictions and limitations. And Medicaid keeps a very close eye on that money because it's their money if it's still there when the child passes away. So Medicaid cares very much what we do with that money. And in fact, you have to do an annual accounting to Medicaid if you are the trustee of either type of special needs trust to make it clear to them, you know, I'm really using this money to take care of the child. I'm not using it to fund my trip to Tahiti or whatever. So first party trusts in particular are subject to a rule that's called the sole benefit rule. And it's something you have to be aware of and make a plan for as a parent who might be the trustee of a first party special needs trust. The sole benefit rule says that the assets in the first party trust must be used for the sole benefit of the beneficiary, meaning you can't even incidentally spend those assets to benefit anybody else other than the beneficiary.
Like you couldn't buy a car that you're going to use to take the beneficiary to and from doctor's appointments. You can't buy the car with a first party trust because especially if the beneficiary can't drive.
Well, you can buy a car to transport the beneficiary if you can show that the primary use of that car is to transport the beneficiary. So sometimes special needs trusts, especially if you've got like a medically fragile child or a child that has physical obstacles and they need the big expensive van with the wheelchair lift, or they need some kind of vehicle that's specially made to accommodate them. You can do that with a special needs trust, even a first party special needs trust, but you have to be able to show the purpose of this car is we're taking our beneficiary to his job or his day program or his doctor's appointments. So, and so it's tricky, but you can do it. But I'm thinking more of things like, if you're a parent that's receiving child support, realistically, what are you going to do with the child support? You're going to pay the mortgage. You're going to buy new tires for the car. You're going to pay the grocery bill. All of those things benefit your child, but they're not for the sole benefit of your child. So for example, if you go from receiving child support in your bank account to having the child support paid into a first party special needs trust, the trustee can't make the mortgage payment out of that first party trust. What the trustee can do is have a room and board agreement. And there are other reasons that you might want to have a room and board agreement, but this is one of them. They can have a room and board agreement where they charge their child who's over age 18 rent. And it is okay for the first party trust to pay rent. So it's kind of money laundering, but it's legal money laundering. But you do have to be careful. You can't just take out money and use it for something that's going to benefit you. You can't make your car payment with the money in the first party special needs trust.
I'm guessing people have tried, Kim. I'm guessing, this has come up a few times.
Hence the rule that you can't.
What about Putting money, what about putting the money into an ABLE account? Wouldn't that work? I mean, it's still.
Do you mean paying child support into an ABLE
Sure,
account?
why not?
So when ABLE accounts first came into existence, and I think that was around 2017, so they haven't been around for that long. The original legislation that introduced ABLE accounts, it was Section 529A of the Internal Revenue Code. And because it's the Internal Revenue Code, it did not address a lot of issues that ABLE accounts bring up. Like, do you pass the income test if you pay child support into an ABLE account? We didn't know the answer to that question for a few years. And then eventually Social Security spoke on that issue, and they have made it clear that you can't make child support payments to an ABLE account. I mean, you can, but it's not going to resolve that issue of the income test. So if you make child support payments to an ABLE account, that money is still considered to be unearned income to the child, and it will still wipe out SSI or reduce SSI depending on how much the payment is. But you can do it the other way. You can make a payment into the D4A trust, in which case we don't have that SSI dollar for dollar offset to worry about. And then the trust itself should have a provision that allows the trustee to make distributions to an ABLE account. And sometimes we actually want to jump through all those hoops because of another rule called the in-kind support and maintenance rule, or sometimes you'll hear it called ISM. The ISM rule is if food and shelter costs come from any place except for SSI or an ABLE account, then that child is going to be considered to be getting in-kind support and maintenance, which means Social Security is going to reduce the Social Security benefit by a third. So the way that we avoid that is, let's say we've got a child who is, the parents have decided he needs to go off and live in this fantastic private facility that costs $2,000 a month, which is way more than SSI. It's impossible for SSI to pay 100% of the cost of that living facility. Well, if we've got the parents paying out of pocket, or even if we have the D4A trust paying for the excess in cost every month, Social Security is going to say, oh no, you're getting in-kind support and maintenance, and they'll reduce the SSI by a third. But instead, we can pay the money into the D4A trust, and then the trustee can deposit the money as needed into an ABLE account, and the ABLE account can pay the excess in the cost of that food and shelter every month. And we don't have the 1/3 reduction for in-kind support and maintenance.
So would a family law attorney typically know all this?
No.
So what should families who are considering a divorce, I guess they wouldn't be families, what should partners? Well, people who are thinking about getting divorced, what should they be talking to their professional about? Because I mean, the family law attorney is there to navigate them through the minefield that is divorce. And I'm certainly not encouraging people to try to do that without an attorney. So how would you bring this up?
Well, one of the groups that I speak in front of a lot is family law attorneys, because a lot of them just have absolutely no idea that these issues exist. And they will, really with the best intentions in the world, they will sometimes unwittingly negotiate, lifelong child support to just be paid to the receiving parent. Or, they just often don't even realize that child support is an issue, or for that matter, other provisions like life insurance. So what you should do if you're considering divorce is go looking for an educated family lawyer who at least understands that these issues are out there. And then that person or the parents should try to incorporate a special needs planner to do that highly specific review of the settlement agreement to make sure that it reads properly.
Yeah, and I'm big on encouraging people to do big C collaborative divorce. Meaning everybody in the party, everybody being used is collaboratively trained. There's provisions that if the clients decide not to go through with it, they can't work with the professionals because they've all agreed they're not going to continue. I just like collaborative training. I like the way the collaborative divorce process works. And candidly, in my opinion, I think it's a lot cheaper than a prolonged, contentious divorce proceeding. Although it might seem more expensive up front, but that would be an opportunity to bring in family law attorney, bring in these special needs attorney, maybe a financial planner, depending whatever you have. But Social Security is not the only thing you were talking to us about when I was at the conference, and you also said something about Medicaid itself, right? I mean, so what was that?
Well, a lot of times settlement agreements will address the issue of how are we going to pay for the children's medical insurance, and what are we going to do about unreimbursed medical expenses? And very often settlement agreements will say, this parent is responsible for maintaining insurance for the children until this age. And this is how we're going to divide up responsibility for unreimbursed medical expenses like co-payments or, whatever. And that's all well and good. I mean, you do have to address that stuff, but you have to also keep in mind, Medicaid is a payer of last resort, which means Medicaid is medical insurance. If you have private medical insurance, then Medicaid is going to sit back, let that private insurance pay for whatever it is that it will pay for, and then look around to see if anybody else isn't responsible for paying for anything. So you don't want your settlement agreement to just say, mom will pay for this percentage of unreimbursed medical expenses and dad will pay for this percentage of unreimbursed medical expenses, because Medicaid is going to be like, okay, we're out. You guys are responsible for all the unreimbursed medical expenses. Don't look at us. So you need to be sure that the agreement is worded to say something like, mom and dad will divide up the unreimbursed medical expenses in whatever way it is that they've agreed to do it, provided, however, that neither party will be responsible for any expenses that would otherwise be paid from any local, state, or federal agency. And that sounds like no big deal. It's a few words, but the price that you would pay somebody to put those words in your settlement agreement will save you a ton of money over the course of that child's lifetime.
And before people pause, rewind, and try to play it again, those are not necessarily the words you should be using. Kim was using that as an example. I'm stepping in here because I
do
know
not
what I
write
would be
this
doing.
into your settlement agreement with a pen.
Be very careful taking everything that Kim is saying verbatim. Okay, I mean, Kim is practicing in Georgia, and again, she's not your attorney; she's an attorney. And Kim, I'm not trying to, I really don't want people taking it and saying, well, this attorney said, what do you mean it doesn't work?
This in here. It'll be fine.
I'm just, maybe I'm just overreacting, but I told you I planned for the worst. And I got to tell you, I love the fact that Medicaid is payer of last resort in my circumstances, because my son's on Medicare. He's a dual eligible Medicare, Medicaid. So Medicaid is paying for Part B premiums. It also pays for the difference. Medicare pays 80%. Medicaid makes up the difference. He also has my health insurance because I'm a retired disabled vet. He's got my health insurance for life. So I don't pay anything. I mean, other than dental and vision, because Medicaid is just not great there. But it's Medicaid is a game changer. It really is in terms of medical bills.
Mm-hmm. Well, and also keep in mind, the people that are listening, there are 7 different types of Medicaid. So when we say Medicaid, that doesn't mean one benefit. It means lots of different kinds of benefits. So when our kids are little, very likely they will get Katie Beckett, the Katie Beckett deeming waiver, which is a Medicaid waiver.
Yeah.
When they turn 18, they age out of Katie Beckett. You can keep it for a little while you're in the process of applying for SSI. But eventually you're just too old for Katie Beckett and you're going to lose it. Then you get straight up Medicaid in conjunction with SSI. Then Later in life, when your child probably qualifies for SSDI, and they can do that if they have a parent who dies or who becomes disabled and starts to draw Social Security, or who retires and starts to draw Social Security. If any of those things happen, then your child who is on SSI, provided that they became disabled before the age of 22, will roll over from SSI to SSDI. And once again, they'll lose Medicaid. You can keep it for this 2-year period that I'm about to tell you about, but 2 years after you begin SSDI, you get Medicare. So Eric, that's probably why your son is now on Medicare.
Well, yeah, I was
But
widowed
you
in
can then get
2012.
there are different types of Medicaid that you can continue to qualify for. And the big one is the comp waiver, which is the big money. And
Again, that's
not
Georgia's
medical
waiver.
care, it's support.
Yeah, and again, that's
So-
Georgia's waiver. You know, and in Palms spells out that if you lose your SSI because of SSDI, you don't lose Medicaid, you can keep it with Medicare.
Right, you can reapply.
Yeah.
It will disappear, at least in Georgia. It goes away and you have to go back to them and go, no, wait a minute. And you
Yeah,
can get
see,
it back.
mine didn't. What happened with me is it was reduced because his Social Security pay was reduced because I had to pay the Medicare Part B premium the first month. And then they reimbursed him the following month, but we never lost Medicaid coverage. And then the comp waiver that you were talking about is Georgia's Medicaid HCBS Home and Community-Based Services waiver.
Right.
Every state will have at least one Medicaid waiver for intellectual developmental disabilities that may be called something different, and it may cover different things.
Yeah, it depends on the state. It depends on how generous your state is. Georgia is not a very generous state.
And it depends when you apply, how long the waiting list is, and yeah, that. So we've covered making sure that the child support goes to a first-party trust, making sure the language for the, health insurance is big. You mentioned life insurance, but I don't think we went down that rabbit hole. Why does that matter?
Well, just like with these other benefits that are addressed in the settlement agreement, many times the settlement agreement requires one or both parents to have a life insurance policy. And the purpose of that policy is to provide for the support of the children if the parent dies. So that sounds really straightforward. But if we have a provision that says you have to maintain this policy to support your special needs child, guess what happens to the life insurance money? It becomes first party.
Really?
The child has an interest in that money.
Wow.
So while people are generally not too uptight about paying child support to a first party special needs trust, they really, really don't like the prospect of putting $1 million into a first party special needs trust, especially because that's, and I'm making up the $1 million, but it's whatever it is that your life insurance policy is for. You know, it's going to go in there when somebody dies. So we have fewer years to use up that money. And anything that's left over at the end of the child's life, remember, has to reimburse Medicaid. So people often don't like that plan. And there are things that you can do about it. And it really depends on how much the parties trust each other and how flexible they're willing to be.
I don't
In
think
some
I knew
cases-
that. I mean, that life insurance in a case like this, because I've recommended that when I was a financial planner. I've recommended for divorcing couples to get life insurance, and it never even crossed my mind that I would need to go to a first party trust.
Well, you can join most of the family lawyers in America in the fact that you did not know that. It's anything that is required to be paid for the support of the child is essentially child support, and it's the child's money. So you can say the parties must maintain life insurance, and sometimes they'll agree that, especially if it's a permanent life insurance policy. So there's, a cash value, there's an ownership interest that hopefully exists forever, right? Because that's the point of permanent life insurance. So sometimes parties will say, this permanent life insurance policy is going to become the property of the parent that is not the insured parent. And if they just own that policy and they're free to do anything they want to with it, it can go into a third-party trust.
Hence the trust. Hence the trust in the other spouse, the other
Yes.
parent.
Because it could also go to the pool boy. You know, it could go to buy mom a really cute car. It can go to anybody that the owner of the policy says it goes to. So because nobody's under any obligation to use that money to support the child, we can put it into a third-party special needs trust.
What if,
Or another provision could be, you know, the parties are just required to maintain a life insurance policy on their lives. End of story.
yeah, I was going to
There's no
say,
requirement for them to do anything in particular with that policy. And
so
if
it's the
that's the
word,
case, they can direct it to a third-party trust.
so it's the word required to be paid, or required to maintain for the lifetime of the child. So if a parent wanted to get life insurance because they wanted to provide for their child, but didn't have it spelled out in a court decree, then it could go to a third-party trust because it wasn't spelled out in a court decree to be part of the divorce proceedings.
Right.
Wow.
So, and the thing that causes that life insurance money to be first party money is that if somebody, let's say, you know, mom is required to have a life insurance policy and she's required to, you know, leave it for the support of the child, and she doesn't. Let's say she names husband number 2 as her beneficiary, which she's not supposed to do, but she does it. And then she dies. The child legally has a cause of action against her estate.
Wow.
Which means it's first party money.
Okay. Wow. My head's exploding. So I'm sure the listeners are probably like, holy crap. What else was there? So we've covered SSI, Medicaid, and life insurance. Is there anything else that we should do it, you know, or should we be looking at maybe having a part 2 to this, because there's even a deeper dive that you could do?
Well, I'm happy to do a part 2 if you want to. There are all kinds of issues that we haven't talked about. Some of them are fairly kind of deep in the weeds. So for example, some planners will address the issue of, you know, we don't want to call something child support, but if it's for the support of the child, it's child support and it doesn't matter what we call it. But so sometimes, and this is not a perfect solution, but it's a solution, and sometimes it works really well. Sometimes people will provide for additional alimony,
Okay.
instead of providing for child support that goes on for an extended period of time. It's called modified alimony. At least in Georgia, it's called modified alimony. And the idea behind it is the parent who's receiving the child support is also very likely to be the caretaking parent, the parent that has the majority of the time and responsibility for taking care of the kids. And so, of course, it's hard to work when you have 24/7 care of a special needs child. So your ability to earn money going forward is hindered. So in some cases, the parties will say, we're going to pay additional alimony to this caregiving parent because the circumstances are going to make it impossible for that person to work as much as they could if they didn't have all these responsibilities.
Wow.
So in that case, that has no effect on SSI whatsoever, because alimony is not income to the child. Now, the reason that the paying parent doesn't like that plan a lot of the time is that it is not payment that's getting made to guarantee support to the child.
So the spouse could use it for whatever they wanted to.
Whatever they want to. So you see that the line that we're walking here, the more control you want to have over the money, the more likely it is that you have to put it into a first party special needs trust. And some people just say, I'll take it. I don't trust my former spouse And I want to know that this kid is going to get taken care of. And if the trade-off is that we have a Medicaid payback at death, then I'll take it.
Yeah, and I'm not, we've gone a long time for this call, so we won't do a deep dive here, but there's also the option to use nonprofits for pool trusts as trustees to be that neutral.
You can, and that's called, if you do that, I've been calling this first party trust a D4A trust. That's known as a D4C trust. So you need to find a D4C trust that will take child support payments and dish them out. And you can, I mean, they're out there, but that is something that you should, consult with a local special needs expert on, because it's not like, we're just going to go down to Wells Fargo and open an account. You have to find a professional trust administrator that administers a D4C trust that has a first party D4C trust and that will take your child support payments every month and distribute them. And you can.
Yeah, and it's my understanding that to be an administrator of a D4C trust, you have to be a nonprofit. But I could be mistaken there.
Mm-hmm. No, that's true. But it's just, it's very hard to find an entity that will do that trust administration, because there's not a lot of money in these trusts. The money goes in and it comes out. That's what they're for. They're parking spaces. So it's hard as a trustee to justify fees.
Yeah.
And even if you're a nonprofit, you have to get paid something to administer a trust. So you can find those entities, but it's a little bit of a search to find one.
This has been incredible, Kim. I mean, I feel, and you've pointed out, we've scratched the surface. So I can definitely see you coming back.
I would love to come back.
This is like, I've got 2 pages of notes, and I thought I kind of knew stuff. I mean, I attended your presentation. I mean,
so you should know everything,
right?
That was it. That was everything I know.
No,
but this is a really complicated area, and the deeper you go into it, the more you realize everything is just so highly fact specific. And to your point at the beginning of this talk, there is no way to listen to anybody give a talk about this and then say, okay, I know exactly what to do now. We'll just take care of this ourselves.
Yeah,
it's minutia.
Yeah, and it's really important, like you said, to bring in another lawyer. And I am going to be the first one to admit I hate spending money. But you know what I hate more than spending money? I hate losing benefits or losing money over the long term. A little bit of pain in the short term is worth it if it's going to get your kid to keep the benefits for the rest of their life.
I agree. And in fact, really, if you do the math, the cost of the first party trust will be made up for in the years that you're getting SSI when you otherwise wouldn't have.
Yeah, and it wouldn't even take that long, I don't think.
No. So,
yeah, this is, I mean, I'm looking at the clock and I'm like, holy crap, we went a while already. Yeah, I'm afraid if we pulled another string, we'd be here for at least a half an hour. And that's not because you like to talk. This is really detailed, important stuff. And Kim, I really appreciate you sharing all this. I mean, this is incredible. I'm a little worried your phone's going to be blowing up now. Do people have permission to, understanding your license and barred in Georgia? You can't give legal advice outside of Georgia. That's what that means. But if they wanted to have their attorney reach out to you, could they? Or
sure.
Awesome.
Yeah, people do that all the time.
What's the best way for people to find you? Are you on all the social medias? Are you?
I hate social media. I mean, I do post things for work, but I'm not one of those people that's going to show you what I'm having for dinner, because I just don't care what other people are having for dinner. So I don't do that. But it's the best way to reach me really is probably to email me at the firm. It's almost impossible to get me on the phone, but I can also give you my phone number.
Don't give
You're
the
gonna
phone
get
number.
my
Don't do it.
voicemail.
I don't answer my phone. My voicemail says you've reached a voicemail that's not checked. Please email Eric at. So
Yeah, I
email
mean,
is the best way.
I do check it and I do the best I can to call people, but really the best way to get me is email.
And I'll
So
put your
my,
email in the show notes because I have your email.
okay,
That's how you and I have been communicating. I'm gonna put a
yep,
link to
it's
your
the
firm in there as well.
kmartin@harrisonheld.com. Is that the one you have?
That's the one I think I have.
That's my work email.
Is that the one you sent me yeah, kmartin@harrisonheld. Yeah.
Mm-hmm.
I'll include a link to your website. And yeah, this was phenomenal. I mean,
Good. Well, I'm so glad you enjoyed it.
Thank you,
It's
Kim.
kind of a depressing subject, but it's
gotta give us a job, right?
Yep. Job security for me.
Well, I mean, people are dying anyway. So even if they didn't get divorced, your job is taken care of.
Yes,
I mean, you still do estate planning, right? And you're not
I
just
do.
you're not just a divorce guru.
No, actually, I love estate planning. It's my favorite kind of work. I do estate planning that has it's almost always special needs estate planning. So I do a lot more third party special needs trusts than first party trusts. And I do guardianships and I do divorce consultation, which is not something I ever would have predicted I would be doing, but here I am.
Well, you obviously know your stuff, and you
Well,
were the
thank you.
first attorney I've heard that was this well versed in it that wasn't in family law. Not well to say not to let me clarify. The family law attorneys didn't have this level of detail. I mean, so you're just
But
really
they
like
don't need to.
right. I mean, you're the first person I found that had all of this tied together. And that's why I couldn't wait to get you on the podcast. I'm like, I don't know where else to find this stuff.
I wish I knew what to tell you. It's hard. The more you specialize in something, the harder it is to find other people that do it as well. And there are people out there that are doing this work, but you just have to look for them.
Yeah.
So a good starting place might be just to find a family law attorney who understands these issues.
And I have found some of those, and I've given referrals to those, to family law attorneys around the country who understand the issues. No, this was awesome. Thank you, Kim. Thank you for your time.
Well, thank you for having me. I'm very excited that you asked me to be on.